I'll call Professor Philippe Sands to the podium. You have the floor, sir.
Mr. President, members of the court, you have had a full week, so these concluding remarks will be brief. The facts are clear, they speak for themselves. I have just a very few number of points to make. First, you've now heard the totality of the submissions of the Gambia on matters of evidence and of law, and we can summarize those submissions rather simply. Whether you focus on the particular circumstances of what passed in the specific villages to which the Gambia has drawn your attention, or on the pattern of conduct across time and place, and whether you apply a standard of proof that requires evidence to be convincing, or a standard that requires the only reasonable inference, it is, we say, manifest. The acts of the Tatmadaw and of Myanmar, killing, causing serious bodily or mental harm, deliberately inflicting conditions of life calculated to bring about physical destruction, and imposing measures intended to prevent births. These acts were committed with intent to destroy in whole or in part the Rohingya group as such. Myanmar has not met its obligations under the 1948 Convention. Myanmar has committed genocide. So too has it conspired and incited genocide. So too has it failed to prevent and punish genocide. So too has it failed to comply with the Provisional Measures Order of this court. Now, my second point against that background is that you have not yet heard from the Gambia's witnesses or expert. That will be for next week, after Myanmar has concluded its first round. And no doubt, in the course of its submissions, Counsel for Myanmar will seek to convince you that the 1948 Convention is somehow not engaged because the facts you've heard this week are invented or exaggerated or depart from the truth, and that Myanmar, in fact, only ever acted by way of legitimate counterterrorism, or because the standard for proving intent hasn't been met, or because the evidence before you cannot be relied upon because of the manner in which it was collected, its probative value, its veracity, its weight, its weaknesses, and so on and so on. To read the pleadings of Myanmar, as we have all done, is to be reminded of Victorian Britain, of Charles Dickens' warnings about the horrors of appearing before London's Chancery Courts. Chapter 5 of Bleak House, and I quote, "It's like being ground to bits in a slow mill. It's being roasted at a slow fire. It's being stung to death by single bees. It's being drowned by drops. It's going mad by grains." End of quote. Well, you'll have a chance to assess the evidence and the testimony for yourselves next week, when the Gambia's 3 eyewitnesses will appear in this great hall. They have, of course, travelled a very great distance to be with us. And they're here for a reason. For in truth, This is really their case. And it would not be right for them not to have an opportunity to tell you, the judges, exactly what happened to them, and for you to hear the voice of the Rohingya directly, and for them to be able to say that you have heard them directly. You have their written statements, and we trust that you have read them. You can read their first-hand accounts. 3 civilians, ordinary folk, people with aspirations like anyone else, targeted not because of anything they ever did, but simply because they happened to be members of the wrong group at the wrong time in the wrong place. Imagine as you listen to them what it means for that reason to lose your wife and 5 of your 6 children, simply because you happen to be a member of the wrong group in the wrong place at the wrong time. In their statements and in their words, you will read about the particular individualized acts of rape and abuse to which they were personally subjected. The killing of spouses, of parents, of children, all personally witnessed. The burning of homes, the destruction of villages, the sight of infants being disposed of by fire or water. The accounts are each and collectively, and by any reasonable standard, deeply harrowing. They're also fully credible, consistent with and supported by hundreds of other testimonies that you have. You'll hear the witnesses, and if you wish, you'll have an opportunity to put any questions you want to them. You're also going to hear from the Gambia's expert, Professor Newton. He's independent and he's authoritative. What does he say about the evidences and the testimonies that are before you, and the arguments you're going to hear in the coming days from Myanmar that it was merely engaged in rather modest acts of local counterterrorism, reasonable reactions to real threats? That's what you're going to hear in the coming days. Well, Professor Newton is blunt and he is clear, and he does not mince his words. No, he says, Myanmar's clearance operations demonstrated none of the characteristics or indicia associated with counterinsurgency. No, he says, the Tatmadaw operations were not random acts of spontaneous and uncoordinated violence conducted by renegade commanders of undisciplined outliers. Yes, he says, the clearance operations were planned and executed based on explicit command guidance and pursuant to orders. Yes, he says, the clearance operations were focused on annihilation of the civilian population. And yes, he says, they were accompanied by all the telltale signs of operational intent. These are his words. I can do no better than put on the screen more of his words. And I quote, any argument that the Tatmadaw's clearance operations against the Rohingya represented authentic or appropriate counterinsurgency is not credible. The clearance operations violated a wide variety of legal and moral constraints. There is no conceivable basis for such operations under modern military doctrine or developed state practice. The attacks were intentionally directed against the civilian population. They were juxtaposed against decades of oppression and human rights violations directed against the Rohingya on the basis of their ethnic and religious identity. The only plausible conclusion from the available evidence is that the clearance operations were conceived, coordinated and conducted with the intention of destroying the Rohingya population on the basis of their ethnic and religious identity. End of quote. That is an expert opinion. And as with the witnesses, you will hear him and you will have the opportunity to put any questions you want to him to test that evidence that he has given. Myanmar had an opportunity to put in counter-expertise. They have not done so. Mr. President, members of the court, in this great hall of justice, as has already been mentioned, each of us bears the burden and responsibility of approaching with the very highest standards of independence, integrity, and professionalism the questions of accountability for the heinous and terrible acts that you are called upon to address in this case. And you address these issues at a particular moment in time. There are some who now say that we live in a post-rules world, that there is no international law, that there is no need for any international law. All that these people say that really matters is the morality of one or two leaders. This is one of the great elephants in this great hall of justice, but it's not the only one. The fact that we are gathered here, and have been for a few days and will be for a few more days, is testament to the enduring reality of a world of rules and of law. Myanmar might like to wish that there was no such thing as a genocide convention, but there is. And it is emblematic of a commitment, a legally binding commitment to a rules-based system. Its meaningful interpretation and application offer the possibility of a riposte to those who say they have a right to proceed as though there are no rules and no constraints on their actions, that they can maim and rape and murder in the name of counter-terrorism or national interest, or that they can commit acts of genocide and other abuses with total impunity and with no accountability whatsoever. To accede to the arguments of Myanmar is to say, in effect, that it can act as it wishes, at will, not in a lawless world, but in a world with no laws. Mr. President, members of the court, as we all know, the eyes of the Rohingya community are upon you and us, as are the eyes of the world. The Gambia has the very fullest confidence in this court to do that which is required by this foundational international convention to protect the rights of the Rohingya community in Myanmar, the rights of the Gambia, and the rights of all parties to the convention. And we also have the fullest confidence that the court will faithfully fulfill its missions as the principal guardian of this convention to ensure its continuing utility and effectiveness in a tough world. We trust, too, that you will not allow Myanmar to discredit and undermine, as it seeks to do, the meticulous, independent, and authoritative work of the United Nations and the reports of its fact-finding mission and the independent investigative mission for Myanmar, work that has been done over many years and at a very great cost and at personal risk to many, many people. Mr. President, members of the court, with these words, the Gambia concludes its first round of oral submissions. On behalf of the team, we thank you for your very kind attention throughout. And that concludes our submissions. Thank you.
I thank Professor Sands, whose statement brings to an end the first round of oral arguments of the Gambia. The court will meet tomorrow, Friday, the 16th of January 2026 at 10 a.m. to begin hearing the first round of oral arguments.